So should we put off the video now?
No, 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 no. You keep it there because I speak to you. It's easier for me
Okay.
to speak and talk rather than
Okay.
speaking to, camera.
Okay, sir.
Okay. So welcome to the program. This is day one, and I will take you through certain very interesting aspects of the subject as well on the CRPC. Now we go very slow, and I'll give you at the end some time to ask questions as well. Okay. So we start now at 4:15. We finish at 6:15 today. Because you lost 15 of minutes of time. Now, this Code of Criminal Procedure of 1973, as we know it, this is the Act number 2 of 1974. So whatever acts were prevailed and were passed though that in the year of 1973, 74, this is number 2. Now, the purpose of this CRPC, it was to consolidate and amend for this particular act the law relating to the criminal procedures in India. Now, there is a framework which is required. We all know from historical perspective, there were Aditya has joined. So there were a lot of different states in India at one point of time, which were all running their own laws, similar, dissimilar, but there was not a common framework which was tying them all. Aditya, can you switch on your camera? I can only see the background. Now, so for especially for the investigating the crimes, the apprehending the suspects, and collecting the evidences in the right way, determining the guilt, innocence by the courts, all has to be uniformly done. And that all was done using the Code of Criminal Procedure 1973. And this this is the second act which is which was passed later in point of time, and this came on force on 1st of April 1974. Now, what are the key provisions around that? Aditya, are you able to switch on your camera? Last time I'm asking you. So, okay. So, Constitution of Criminal Courts and Offices, what it includes: powers of all the courts, powers of all the police officers, arrests of persons, possession, a process to compel appearance and production of things, inquiries and trials, appeals and revisions, execution of decrees and orders when they are passed, bails and the cognizance of the crime, search and seizure. So all these can include together are included together in the CRPC. Now, why CRPC is required? Somebody will ask. Although we talk about the initial framework. So this is a very important legislation, as I say, which produces a framework of administration of the criminal justice. We can say in one line, this is an important framework to help administer the framework of the administration of criminal justice. Now, there are several key reasons which the CRPC is essential. So if somebody asks you why CRPC is essential in exam or somewhere, you can come back and say there are 7 essential points why CRPC is required. One is it's a legal framework for criminal justice. So this is the first one. It says it's a legal framework for the criminal justice. It's a very structured process to bring in the right clarity and the consistency. So it provides a comprehensive legal framework about, what are the courts, what all are the basic definitions which are not part of the IPC or BNS now, which are what exactly the framework looks around, what are the powers and the scope of the officers working in those courts or the places of justice, who all are the kinds of people who can provide justice, how the trial can happen, how the stages of trials should happen, how the investigation should happen, what the administrative folks should have, the powers limited to them, and what the police can uh, do in terms of investigation. Now, all of these is completely structured and placed in one place. That's the reason we call it as a CRPC, structured process. It gives a clarity and consistency. Why clarity? Because it gives a clear understanding of how the criminal justice system work and what cannot be done, what are the exceptions, etc. So it's very clear in almost all the scenarios. Second thing why it is important is it helps in protection of rights. The accused also has got a right, not only the victim. The accused also has got a right. So in case of an accused's right, CRPC does protect an accused as well, because until and unless in the court of law somebody is not proven guilty, the person we call him or her as accused. So the accused might be at one point of time, might not be criminalized or any order passed against him or her, which means an acquittal can happen. In that case, from day one, an accused cannot be treated like a guilty person or a criminal. They should get the right kind of structure and process to protect their rights as well. So it does take care of the accused right, although primarily any law, as we know, takes care of primarily of the victim's right. So victims' rights are also there, accused right is also there. Now, if we come to the third reason why CRPC is important out of the seven we were talking about, it gives an order and control in criminal proceedings. Now, criminal proceedings are proceedings where sometimes, for most of the time, there is a life which is on stake, which is a liberty which is on stake, which is somebody who is a highly injured in that sale. So there is quite a chance of emotions, etc., to come and build in, which might cause a lot of issue in the justice system. One second, I have to switch off my sound. So in that case, there is a role how the magistrate should work, how the court should work. So this is established by the CRPC. The roles of various judicial authorities, their scope, their limitation, their work distribution. In fact, a clear, strong framework so that there is an order which is maintained. In fact, the police, quite a possibility there is quite a possibility that the people who are doing the investigation, those people might get either willfully or with lack of knowledge into a situation where those police officers or other administrative officials might go and cross the limit in terms of not only working in direction of what is prescribed and what is supposed to be done towards that criminal justice of that particular matter, they might go beyond that as well. So in that case, this is a framework, firm framework, rigid framework, which helps us to control their activities of seize, investigation, and etc. Fourth, what is very important thing for CRPC is why CRPC is there is facilitation of law enforcement. Now, one side we talk about the law enforcement agencies to be controlled and the right kind of powers to be uh, provided to them. In fact, a huge control also to be set so that the criminal justice system is not going haywire. So the facilitation of the law enforcement is also done through CRPC. So exactly how they arrest the suspect, when they can arrest, what are the procedures to arrest that, how to conduct the investigation, how to produce the documents, how to gather the evidence, how to enhance the effectiveness of the crime investigation. So this is also the number four point is the facilitation of law enforcement is also done through CRPC, which helps in a judicial oversight as well. So if the things are done by book as per process, a judicial oversight can also happen accordingly. If some things are not completely in control and there is no such framework available, how the judicial oversight can happen? Lost a lot of time would have been in on every individual case. Judiciary will spend on waste on correcting those steps. Number five is efficiency in the criminal justice system. All of this, what we have talked about since one to four, is nothing. It's bringing an efficiency in the criminal justice system. So specific procedures, timeline, techniques, trial methods, investigation techniques bring nothing but a efficiency. If these things are not known, every time everybody has to be briefed onto that, then what would have happened is the efficiency of some person might have been very wise. And if CRPC was not there, they might have thought in a very systematic way and brought the investigation to a systematic closure. That might not happen if CRPC procedures were not there. So it brings an efficiency, streamlining, and alternative dispute resolution as well. Because at certain stages, certain places in CRPC, we talk about how out of court settlements can also be done. Depending upon the provisions inside the CRPC. Sixth is adaptability to changing legal contract. This is very common sense based topic. So if you have nothing in place which is in order and which is something which is going to help you systematically to run a judicial system for criminal justice system, what will you adapt? So there should be a baseline which is completely cleared, optimized, and that has to be used, which is CRPC now. And when you have something in place and then there are changes in society which happens over time, then you have a chances of adapting that legal system with time. So that is why the adaptability to changing legal contexts is also done by CRPC. Seventh thing, which is very, very important, is public confidence in the legal system. So there are incidents where, we get some very strange orders coming from the judges. We see some very strange uh, crime happening. But a transparency and a faith is established back into the legal system by the CRPC procedure itself. So nobody is beyond and above and beyond. In fact, the courts and the judges are also not beyond that. And that instills the public confidence for the legal system. And this instills somebody, confidence in people about the fairness of the trial system as well. Because what happens is, if there is not something which is written in book and which is not, you know, uh, uh, in a form of some kind of law and some kind of act, how would you go back and challenge that to be right and wrong? If the procedure, there is established procedure which is written, which is a very rigid system, which has a complete details in each and every related to the criminal justice system, then only you can come back and have a faith into the system, because until and unless there is nothing written, how would you validate that? How would you ensure that this is being followed? So that insurance comes from the hard scriptures into these such kind of laws. And this is something which is going to help us to help instill trust and fairness in the judiciary. So these are the seven important points which helps us to uh, via CRPC we get help. Now I'll come to chapter number 1. So we'll do chapter 1, 2, and 3 today, and I'll keep the house open for discussion at the end, in interest of time. And because we have a recording, I don't want to disturb the recording for overall lecture. So once the lecture is completed, we can talk about the question and answer at the end. That will also be recorded at the right appropriate place in the video. Now, chapter 1, this is something which says, this is normally as any other act. This is a short title, extent and commencement. And this has been amended by the Reorganization Act of Jammu and Kashmir. And the word Jammu and Kashmir, which was exempted, has been added again back. That particular clause is removed. But still, it is not applicable in certain places for the safety of preservation of the some native legal systems and preservation of some native tribes in the Nagaland. And only chapter 10, 11 uh, are applicable for those areas. So there are some very important definition clauses which I will take you through. So chapter 1 has got multiple definition clauses. Okay, but what I'll do is I'll take you through in detail on some of them which are very, very important. Important in the sense difficult to understand. Now, the first definition talks about the bailable offenses. So, bailable offenses, the word comes from bailing out somebody from a situation. Bailing out is a word saying to rescue somebody. So, a bailable offense is something where a person has a possibility given by the law, written as per the IPC, BNS, or CRPC, that those offenses which are bailable or some are non-bailable, and the bailable offenses are the one where you can request for a liberty from the court, that you are not arrested, in terms of you giving a surety of being available and being cooperating with the court and the investigating agencies. So this is about the bailable offenses. Now, charge. Now, charge is one important definition. The reason for students I say charge is an important statement is, charge is a very common thing which happens in the court. Whenever a case is, reaches any criminal court, the very first actionable part which happens is the charge. So charge is something which is understood very vague by the students, because of it's just one liner saying charge includes any head of charge when the charge contains more heads than one. Now I'll give you a background how it happens in the court. So let's talk about a hypothetical situation. I'm talking about definition charge, section 2B of CrPC. A theft has occurred at a local jewelry store. Now, where several pieces of jewelry worth significant value were stolen. The police conducted an investigation, gathered evidence, and arrested a suspect. His name is, say, Arun. So, Arun was arrested based on an eyewitness account and forensic evidence. So, we got his fingerprints, we got his picture on the CCTV camera. People have seen him while he was running out, his mask slipped, and people have seen him. So, people knew, oh, this is Arun. Now, what happens first is filing of charges. So the FIR is done, the arrest is made, and after that, police files a charge sheet in the court. So after the completion of the investigation, the police files a charge sheet, which is called as a police report in terms of CrPC. We call it as a police report. The court proceeding then starts, and how the charge happens to understand charge. So whenever the charge, when you say the status of that particular matter in any tool or on the court list, you see the charge is the status. So charge means the judge will ask to the accused person that day that, first of all, so and so, are you somebody who is aware of such kind of theft has happened? So the person is come back and say yes. The prosecutor will come back and say yes, first of all. Yes, my lordship, this has happened, and Mr. Arun is one of the person who is part of it, and he has committed the theft as per the evidences and the the documents and the eyewitness account. So then it's a responsibility of the prosecutor, the government lawyer, as you say, the APP. He will come back and say, we seek, my lordship, to charge him against so and so sections of law. He has to be charged for so and so attributes of the crime, theft, robbery, whatever it is, and so IPC sections and BNS sections, which is as part of the complaint made and registered by the police and the investigation reports. Then the judge will come back and say, are you aware of such an incident which has happened? The very first question is asked to the accused is, now we are talking about charge. I'll come back to the definition once I tell you this story. So do you understand those charges against you? So the person will say, yes, I understand what charges are against me, which means the person is aware basically what all charges are framed against him. He has a liberty to come back and say at the charge sheet, my lordship, I'm not aware. Then it's court's responsibility to give him time and ask police personnel to provide the details to him, the copy of the charge sheet and etc. to him, so that he is made aware of that particular situation. Once it is done, then the charge question, final question comes from the judge to the accused person is, do you plead, how do you plead to the charge? The charge of theft in this case, how do you plead, Mr. Arun, for this charge of theft? He has to come back and say guilty or not guilty. If he says guilty, then also it doesn't happen that the trial is stopped at this very same point of time. It's the role and responsibility of the courts to ensure in the fairness of the justice system to still go ahead and at least do a summary trial to investigate what was the reason this crime has happened, to give him appropriate punishment. If he says no, that I'm not guilty, in that case, then the judge will say, we are prepared to get the evidence, we are prepared to run the trial, including the witness, etc. So this is what is charge. So charge includes any head of charge when the charge contains more heads than one. So charge is actually, in layman's language, is the number of sections which have been applied against you, which means the number of criminal individual activities attributed to you in that particular commitment of the crime. So that is what is charge. So coming to point C, definition is cognizable offense, which means an offense for which an cognizable case means, see, cognizable word, offense word comes from a word called cognizant. Cognizant does not mean the name of the company cognizant only. It means cognizant means being aware of, having a cognizance of. So cognizant word brings in the cognizable offense, which in literally it means a police officer may arrest that person without any warrant if this is a case of an cognizable offense, and that is listed in the schedule. So as per the schedule, whatever are the cognizable offenses which in which is listed in the schedule 1, a police personnel can come and arrest somebody, providing the right uh, set of activities is noted and understood by him. Now, complaint. This is one again very important definition, which is point section 2D. In the simple definition terms, it says complaint means an allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report.
I'm not quite sure how to help you with that.
My Alexa is speaking. Okay. So, complaint is also one of the definition which has to be understood well. As I said, definitions, I'll stop at the points, certain definitions which are very, very important. So I stopped at charge. I stopped at bailable offenses. So complaint. So as the definition says, a complaint is any oral or a written submission to a magistrate excluding by any report by police report. So charge sheet is not a complaint. Police report is excluded from being called as a complaint. A complaint can be allegation made either orally or in writing. It has to be a magistrate, and the purpose has to be to prompt a magistrate to take action under CrPC. So all the right ingredients or the story has to be there, which can prompt a magistrate to take an action further. But it does not include a police report. So the part clarifies a complaint differs from a police report. So charge sheet cannot be considered as a police report. Because the police report is nothing but a research paper. It is something which is an investigation report. It happens after a complaint is made. It happens because a complaint was made. So this is complaint, and in complaint, no way, in any way, a police written complaint can be, a charge sheet can be considered as a complaint. Now I'll skip EF, which is High Court, definition of High Court and definition of India. I'll come to point number G, section 2G, which is inquiry. Inquiry means every inquiry other than a trial conducted under this code by a magistrate or court. So inquiry means every inquiry other than a trial. So if any every inquiry other than the trial which is happening under this particular code is considered an inquiry. Now, what is the purpose of this? The primary aim of an inquiry is to investigate and ascertain whether sufficient grounds exist to believe that a person has committed an offense. An inquiry is a preliminary step that takes place before a formal trial. So before a formal trial space, which means the inquiry which always comes before the actual trial. It is conducted by a magistrate or a court. So an inquiry is typically by a magistrate or a court. By simple questions, you can answer in a written affidavit or you can written in a verbal file. So normally in the course of action of court, normally such responses sometimes are also required to be filed on affidavit as well. Now, exclusion of trial. The inquiry is excluded of the trial. Inclusion of section 202 proceeding is also part of the inquiry, which is any discharge if happens. If in case the magistrate or the court believes the charges which were filed against a person is not necessary, is not sufficient enough to continue the trial, at that stage of inquiry, the trial can also be dropped by the court. And that is the reason why the inquiry happens before the start of the trial, because this is something which is also a deciding factor by the magistrate or the judge to ensure if really a trial is required or not. And if required, then in what all directions, what evidences are required. For example, take a scenario. I've written a scenario for you. See, suppose a local resident, Mr. X, files a complaint alleging that somebody damaged his property out of malice. Here's how an inquiry under section 2G might unfold. So this will give you an example understanding how inquiry happens. So these are very, very important definitions which is required in the practical aspect of the court. So Mr. Ramesh submits his complaint to the magistrate claiming his car was vandalized by neighbor Mr. X. The magistrate reviews the complaint. When it comes to a magistrate, reviews the complaint, now the inquiry stage comes and decides to conduct an inquiry to ascertain the fact. This may involve calling Mr. X for questioning, on whom the allegation is for damaging the car, gathering evidences through police investigation, awaiting for the charge sheet, and possibly examining witnesses also, if any, available. So during the inquiry, the magistrate may sometime also visit the alleged location to see the surveillance. I mean, these were the old days. Nowadays, mostly CCTV footages are also observed by the courts. And they might also require interviews from the neighbors, which is part of the charge sheet. So all these things constitute the part of the inquiry. Based on that, if there is, for example, in this case, Mr. X was nevertheless, he was not seen in the vicinity in any of the CCTV footage. Somebody else was seen vandalizing the car. If there are evidences, witnesses available who say he was in some other city, sitting there, and there are clear evidences which could be considered, if those evidences are available there, so in that case, the inquiry will go in a direction where the judge might come back and say, we need a discharge of this particular matter, and that matter will be closed at that point of time only. Otherwise, in all the other cases where even there is a slightest of suspicion where he might be in a CCTV camera, in a practical case where we might not see because of the angle of the camera, we are not able to see that person directly vandalizing the car, but when he comes close to the car, we hear some sound in the CCTV camera if there is an audio recording available, or probably we see him coming to some pillar or somewhere where he's not available, but we see a stick emerging out in the air and bashing the car windshield. So anything which is suspicious, in that case, through inquiry, the judge will come back and say an outcome of the finding of the inquiry is that offense may have been committed or may not have committed. So in those cases, the inquiry is a very, very important stage. So normally students pass through its definition clauses, but these are very, very important practical aspects. So inquiry is something which when you practice, this is something going to be very, very important for you, for your client, if you are looking for a discharge. Now I'll leave in between couple of definitions like investigation, judicial proceedings, local jurisdiction, metropolitan area, NC non-cognizable offenses, notifications, offense, officer in charge of police station. These are very basic definitions. You can go through it yourself. That does not need much. In fact, the jurisdiction, judicial proceeding, metropolitan area is covered further in this lecture. So we'll touch up on those when we come to those sections. Now let's come to the definition called place. Place is again section 2P, which is again a very, very important definition for you to understand how CrPC works. Place, if you see by definition in the Ware Act, it says place includes a house, building, tent, vehicle, and vessel. But in practical life, this is more than what it is written here. Now, a broad interpretation of the same is the term place has been defined broadly to encompass various types of locations where a crime might occur. Now, a crime can occur in a rigid place and a permanent structure like a hall, a cinema hall, a place of residence, a common area of an apartment or office or college. So such houses and building, the permanent structures, or it can happen on a temporary or movable structure also. For example, a tent, a canvas tent, there also a crime can happen. A vehicle, there also a crime can happen. For example, certain very common crimes which happen in the tents or in the movable vehicles is the cases of adultery. So those kind of crimes are defined under this. So if somebody comes back and says a police officer has charged me when I was sitting in my car and I was doing something with somebody and which was considered a unnecessary display of affection and sexual activity in a car in a public place, and the police has no right to jump into the vehicle because this is my private place. No, a car on a street is a public place, and this is something which is considered within the definition of place, and it comes on preview of the CrPC for any matter which is initiated for any accused persons in that case. Now, purpose is the definition ensures clarity in the legal proceeding about what constitutes a real location for investigation, so or legal action. So if a tent or a car in that case is also a legally correct place where such a legal charge can be initiated and such a legal action can happen. So law enforcement can collect evidence and conduct inquiries wherever necessary. So this helps our police and investigation teams to help them to collect evidences and conduct inquiries even in such places which are defined under places. Because common understanding is place means a physical place, which is a hard structure, maybe a house or a building. But these are also part of places. Now, let's take a scenario. For example, a crime related to drug trafficking. It happens mostly in the moving vehicle, buses, cars, trucks. Now, law enforcement may search a suspect house where they suspect illegal drugs or substance to be stored. But the house is a place. If they want, on a credible evidence or on a credible belief, they can also go back and search his vehicle running on the street or parked in the vehicle, in the premises. So a car could be stopped by the police if they have sufficient reasons to believe, reasonable suspicion that it is being used to transport an illegal substance or something which is illegally held or not to be in possession of somebody, for example, arms. So the vehicle is considered a place as per CrPC within the meaning of CrPC and allow the police and the law enforcement agencies to search and gather evidences lawfully from a place which is a vehicle as well. And tomorrow, if you stand as a public prosecutor for the law enforcement agencies and somebody challenges, you can talk about these case laws. State of Madhya Pradesh versus KAZ 1995 is a Supreme Court matter, and Suresh Kumar versus State of Maharashtra, which is 2007, and High Court matter. In these both cases, the ruling say,
Excuse me, sir.
sorry,
Sir, if the vehicle is in a secluded area, then
no, please note down the questions. We'll entertain the questions only at the end. You may note down the right sections which I'm
okay,
talking
sir.
about. We'll talk about it. We don't want to disturb the recording.
Okay, sir.
Now, State
Okay.
of Madhya Pradesh versus KAZ 1995 and Suresh Kumar versus State of Maharashtra. Now, in both the cases, what the ruling says, the court has held that lawful search can be conducted in any place as defined by the CrPC, emphasizing that even temporary structures like tents or canvas-made houses or paper box-made houses could be subjected to search under the law if they accommodate criminal activities and even if they are parked or kept in an isolated place. Now, Suresh Kumar ruling says the court ruled also in favor allowing the searches of vehicle as places suspect of criminal activity, supported by evidence that they may contain contraband, and the vehicles itself were parked in a secluded area and they were hidden from the public eye by covering them as well. So in that case, even if a vehicle which is considered, or a tent, even a canvas house or a paper house is a place, please understand. And even if it is hidden from the eyes of the common people, even it is something which is stored separately somewhere, then also the place is still considered a place in preview of CrPC for applying of any legal action and to subjecting to any legal trial around that, even if a car is parked in a secluded area. So key takeaways from this particular definition clause of place is it's a comprehensive definition. It's a big definition, which is a very, very important aspect missed by us when we study, that this gives an authority and broaden the scope of the legal law enforcement agencies to be reaching out to those areas as well. Plus, in any trial, if it is required, a place has to be brought into the purview of the trial. Both moving or immovable places are considered. In case laws emphasize the importance of lawful search specified places, the law enforcement agencies can go anywhere. So place is very, very important definition. Coming back to next definition, I'm leaving some definitions in between and I'm coming to definition for number 12, 12W, sorry, W. So it's 2W. It says summon case means a case relating to an offense and not being a warrant case. Now, the moment the definition is read, summon case, summary trial, warrant trial, all those things are very confusing things. Okay. So I'll pause at this point, which is 2W, and I'll cover topics until W, W, and X to make you understand what is the difference between a summon and a warrant case, which is very, very important. Now, in context of criminal law, which is CrPC in India, there are two types of cases, basically, summon case and warrant case. Now, what I would say is the moment you hear these words, the word should itself click in your mind with the literal meaning of the word, what exactly it means. So a summon case is defined under section 204 of CrPC. We'll reach out there soon. So wherein the nature of the offense is typically less serious or a bailable in nature. So a thumb rule is a summon case is the one where it's a less serious criminal. We are talking about criminal matters, so we'll only keep our minds towards the criminal cases. So all the criminal cases which are typically of bailable offenses, which are lesser crime. So the accused is summoned to appear before the court. So what happens is you have committed some crime which is bailable offense, and there is an NC filed against you, non-cognizable offense, or a simple complaint is converted to NC and this is filed against you. Now, against the non-cognizable crime, police cannot make an arrest. We know that from the definition that police can only arrest you without any warrant. If it's a cognizable offenses listed in the Schedule 1. If you are caught killing somebody, if you are caught committing a robbery or raping somebody, so those are one of couple of cognizable offenses. Example, if we count, in those cases, it's a responsibility of a police officer to immediately get into action. In fact, the Maharashtra police laws also, in fact, the All India police laws manual also asks police to, in spite of being off duty, in spite of being not in the jurisdiction, to act on behest of the police department and to arrest that person temporarily and to hold it to and hand it over to the nearest police station. In fact, a common person also has a right, as per the law, where they can also make an arrest temporary for reasonable reason and hand it over to the police. So cognizable offense, wherever it is, it's a bigger crime. So whenever the crimes which are of less serious and a bailable in nature, those cases are run in summon cases, are called summon cases. While the warrant says itself a warrant is required. So a warrant case is as per uh, section 204 only of her CrPC are more serious crimes. So warrant is issued by the court to arrest the accused. So it is, it's not always like Bollywood. The people who commit a crime, they have to be, in all the cases arrested immediately and dragged to the police station, arrested, sent to the jail. No, it doesn't happen. There is a procedure for that always. We'll come to know in the CrPC. You have to serve certain notices. You have to make the person aware of that particular crime, what he or she has done, give ample time, and then arrest that person. So a warrant is issued by the court to arrest the accused. In some cases, those cases are called warrant cases. These are mostly offenses punishable by death, life imprisonment, or terms exceeding 10 years. Now, what are the nature of the offenses? How do we define? Now, we define from the type of the cases. Now, summon and warrant cases could be defined in terms of the nature of the offenses also. So, as I said, the summon cases offenses are punishable with less than 2 years of imprisonment. So, anything which is punishable less than 2 years of imprisonment, these offenses which require stringent legal scrutiny to punish somebody. So, which is less than 2 years of imprisonment, for example, petty theft, certain traffic violations, or mischief. So all those things are considered under summon cases. While the warrant cases, of course, everything apart from that. So murder, robbery, grievous hurt, kidnapping, all those things. Financial misappropriations, all those things come under warrant cases. Mode of summoning. Now, in case of summon cases, the summons usually it's a written paper. It's a written order, small order, to appear in the court on a specific date. So if you receive a piece of paper from a magistrate or a court, you have to appear based upon the summon. You were not arrested. You had made a traffic violation. You have been sent a traffic challan. You have not paid the challan. Then over some time again request comes. Then the Lok Adalat comes. Then also nothing happens. Then uh, court is department initiates through third party or through other companies also, or through directly in department also, files matters in bulk against people, and those people get a summon to appear first in the Lok Adalats and then into the normal motor vehicle tribunal or criminal courts as well, sometimes magistrates as well. So those people have to come and appear in those courts depending upon the summon. Were you arrested when you did a signal jump? No, you were not. It's a petty crime, it's a small crime. So that is why it is a summon case where a summon is given to you, which is an order given to you to appear in front of any court. Warrant case is where an arrest happens, where arrest has not even happened prima facie in first instance. It might happen because of the court's recommendation or a suo motu cognizance of a court. So all those things come under warrant in terms of mode of summoning. In terms of procedure, if we say the trial procedure is very straightforward. For a traffic violation, what all you need? It's a very straightforward matter, right? So the court will conduct a simple summary trial. Now, the moment I say summary trial, we open another can of worms. Now, we were talking about summon cases, warrant cases. Now, what is summary trial? So we'll deal it the moment we complete this part of the definition. So based on the simple, straightforward evidences on a small scenario, it is disposed immediately, such cases, through summary trial. And the warrant cases take the normal route, like the evidence presentation, the examination of the witness, of the accused, of the victim, and all those the procedures which has to be followed. Now, summon case and warrant case we have understood enough. The key takeaways from summon and warrant is, which is the section 2W to section 2X of CrPC, is seriousness of offense, arrest procedure, and the legal rights. Depending upon these three, we define. Now, in terms of talking about summon case and the warrant case, I talked about summary trial. So there are multiple types of trial available. So summary trial is associated in my definition in the summon case. Why? Because summary. What is summary? Do something in a small zest. If you have a huge book and somebody says, or a big chapter, somebody says, okay, can you write a summary about what you have understood today in the session, or what have you read in the book in this chapter? You write a small paragraph, which might be a fraction of the size of that particular chapter, which is a smaller pack of information. So very same in the very same thought process is which is aligned in when we talk about summary trial. So by definition, a summary trial is a type of trial for lesser offenses, of course, because the bigger offenses will need bigger scrutiny. The whole purpose of the courts is to ensure the appropriate scrutiny is done. So the scrutiny is lesser required in summon cases, and summary trial can be done. And this is very efficient, very fast, and this has not very complex procedures. So you do not need the formal evidence presentation stage. You don't need formal documentation stages. You don't need a specific charge session. You don't need specific, examinations, cross-examination, etc. You straight away get into a court in 2 or 3, sessions with the court. You will, the judge can come and quickly give a judgment out of it. So this is a very short and sweet way of doing judgment for a smaller matters, and which is based on the prima facie whatever evidence is available. The magistrate normally does a summary trial. So a summary trial is mostly taken care at that point of time, then and there, which is considered in section 260 to 265 of CrPC. We'll reach there, then we'll read it in detail. For example, as I said, traffic violation. Now, if there is a more serious offense and bigger crime, in those cases, a session trial can happen, where your matter has gone to a session court and a session trial happens. Or in some cases, some applicable offenses, it is quite possible that a magistrate trial can also happen. A small matter has happened, probably during some special days, maybe 144 is applied, maybe election is going on, maybe some disease has spread. So these are also smaller offenses, usually non-cognizable, and imprisonment up to 3 years can be tried in magistrate trial. Right? So summary trial, session trial, and magistrate trial. Coming to section number 3, construction of reference. This is also very, very important. Now, by definition, you can read in the book. It's a huge definition of half a page or more. I will not read that, but I'll take you through the understanding. You can read it later, and you can listen parallel to this lecture then. The Indian legal system the CrPC, we have a term called judicial magistrate. It might be a first class or a second class. So we call what they call we call them in short is JMFC or JMC. I'll just take some water. So the judicial magistrates are of two types primarily, which is of first class and second class. First class is commonly called as JMFC, and second class called as JMC. So JMFC and JMC. Now, any reference without any qualifying words to a magistrate, how do you understand? So when you start to read the CrPC, you have a lot of places where even IPC, for that case BNS, you have a table, a schedule which says which crime is punishable by which magistrate. So which magistrate you have to understand from plain reading of the IPC and plain reading of the CrPC schedule. That is what is construction of the reference talks about. So in relation to an area outside a metro, so there are two types of areas which we talk about. One is a metropolitan area, one is a non-metropolitan area. Any area by definition of CrPC which is beyond 10 lakh people, 1 million people, it can be defined by the state government as a metropolitan area. Otherwise, it is not a metropolitan area. So if a metropolitan area or a non-metropolitan area, the judges are called differently at this level. So you call judicial magistrate here and then you call metropolitan magistrate there. So in area relation to outside a metropolitan area, as a reference to a judicial magistrate, in relation to a metropolitan area, you call it a metropolitan magistrate. So judicial magistrate first class is a type of magistrate who has higher authority and jurisdiction compared to a judicial magistrate second class. By the name it goes, right? So the jurisdiction is different for JMFC and JMC. The JMFC can handle more serious offenses, including those punishable by imprisonment up to 3 years also. While they can conduct trial for both summon and warrant trial and have authority to grant bail also. So JMFC can grant bail as well. For example, they can work on theft cases, criminal breach of trust, assault case, anything. While the JMC, as the name says, it's a second class magistrate, this judicial magistrate second class handles less serious offenses, and the jurisdiction is for 1 year or less. Offenses of less than 1 year or 1 year, up to 1 year. So if we see a comparative difference, so the jurisdiction is the JMFC handles serious offenses punishable by up to 3 years, while JMC handles up to 1 year. The trial, mostly the JMC conducts the summary trials, while the JMFC can conduct both summary and regular trials. The power of JMFC is to authorize to grant bail, while JMC has a limited power. And minor theft, public nuisance, minor assault, somebody has played high in the night, somebody has done a small pickpocket, maybe a small nuisance somebody has created, public nuisance. All those things comes under JMC's court, which is the judicial magistrate of second class. So this construction of reference first says, the moment we talk about the reference to a magistrate of a second class or a first class, you should understand, if you're not a metropolitan city, that we are talking about JMFC or JMC. But the moment we talk about a place which is a metropolitan city, we then talk about the chief metropolitan magistrate and the chief metropolitan magistrate. So the mapping is exactly same as JMFC and JMC. So it is chief metropolitan magistrate or metropolitan magistrate. Now, this is very, very important to understand basically the schedules what you read in the various laws and various sections. And the moment it is said a magistrate, trial level by a magistrate, you understand which magistrate. So it constructs it. This section helps you to construct the reference. Until and unless it is something which is not specifically mentioned somewhere. So to a magistrate of the first class, if somebody says in some law, it automatically means a reference to a judicial magistrate of the first class. If in some law says a magistrate of the second class, this is trialable by magistrate of a second class, they directly means a JMC. So in metropolitan areas, basically, this is considered as the Chief Metropolitan Magistrate or Metropolitan Magistrate. So CMM or MM. Now come to section number 4, which is trial of offences under the Indian Penal Code and other laws. This is a very simple section. It simply talks about any offence which is listed in the IPC, now BNS, is trialable, and the procedures under CrPC can be used. The second point says all offenders under any other law can also be investigated under this CrPC procedures. Coming to chapter 2 now. Section 6. Now, how many courts we have depends upon a lot of parameters established by the central government, state government, and the demography. So we have, besides the High Court, besides the tribunals, besides the Supreme Court, which is established by Regulation Act of 1773, every state will have 4 types of criminal courts. Courts of session, JMFC first class or a metropolitan magistrate, JMFC second class, JMC, or a metropolitan magistrate or an executive magistrate. Now, what I will suggest is you focus first upon how the sessions are defined. So, the moment we talk about the courts, court of session, judicial magistrate, second class, and executive magistrate, the very first word which comes to mind is court of sessions. So, what is court of sessions? Why it is called court of sessions? Which is very, very important. Does session means crime? Does session means a bigger crime? No. The court of session name itself, I will focus on this because this will automatically build up the knowledge about remaining 4 courts, the powers of the judiciary magistrates, their hierarchy, etc. automatically when you understand this concept. Now, what is court of session? So, there is something called territorial division defined in section 7 of the same CrPC, which says every state has to be divided into small divisions, session divisions. Now, what is a session division? So every session division is decided upon 2-3 different parameters by state government or the central government. What are the 3 different parameters? One is the geographical area. It has to be divided into, the state has to be divided into various sessions division based upon the geographical factors, ensuring equitable access of justice for all areas within the state. So a state has to be divided in such a small sections that with respect of number of judges, the facility being created there, and the number of population available there, a session of such people could be given justice in the criminal matters, which is also a function of a population density. Normally, they consider for up to 10 lakh or close to that population, they consider to be considering as one session area and existing infrastructure. So even if I have a 10 lakh person infrastructure, which I wanted to divide into one session area, I might not have possibility to generate a facility so big to cater to those people. I might divide again into 2 different sessions. It will become 2 session jurisdiction. So because of the session of the people divided by demography and possible of creating infrastructure for the running of a legal justice system, the area is divided. And for that area, there is one criminal court, which is called the courts of session. So that is why the name of courts of session has come. So a couple of courts of sessions are created in every state to ensure every district and the rural area surrounding it are covered under that particular session court. Now, this definition of session is done in consultation with with the state government, with the high courts. The session division, district, subdivision existing in a state at the commencement of this court shall be deemed to have been formed under this section. Section. Now, similarly, for section 8 perspective, metropolitan area, anything anywhere which is more than 10 lakh people, it's a discretion of the state to define any such number, but beyond 10 lakh number, they can call it out a metropolitan area. What changes when you call it metropolitan area? Three things changes. One is the courts are called metropolitan courts. Second thing, the chief justice CJM and the chief judicial magistrate etc. are called chief metropolitan magistrate etc. And third thing, the powers of the police commissioner increases in those particular metropolitan areas. So as far from the commencement of this court, each presidency town of Bombay, Calcutta at that point of time and city of Ahmedabad shall be deemed to be declared under section 1 to be metropolitan area. The state government has a power, if you see section 8, 3 and 4, or even 5 as well, there is quite a possibility with some new regulation by the legislature, we might redefine a metropolitan area, or we might undeclare some place as a metropolitan area, or we can extend or reduce the size of the scope of that particular metropolitan area. In all such cases, the new definition will prevail and the new courts will be organized in those areas to operate. But if any matter which was running in, say, for example, Metropolitan Court 1, which has now lost that particular jurisdiction area in that district, which has gone to 2, either they have to transfer the matter to the new court, or it is all possibility that the previous court can run the matter as per CrPC. So because of metropolitan areas, section 8 comes and talks about a special area condition where you might call it as a metropolitan area. You have new officers, new named officers. You have some powers which are different for police. And then you have chances of getting it undeclared as a metropolitan area or might be called as a metropolitan area. So in all such cases, the metropolitan, whatever dynamics can happen, is covered under metropolitan area. Now, Court of Session, section 9, the state government shall establish a court of session for every session division. So every session division we have made considering all the geographical, population, infrastructure possibilities. So for that, state government shall establish a court of session, and which will be presided by a judge to be appointed by the High Court. Now, there are judges which work in the session court, and what they are called primarily, the judge is called as a session judge. Now, session judge, additional session judge, and assistant session judge. There are 3 types of judges. All right. So one is a session judge, which is appointed as the head of that particular session court, then additional session judges, and then assistant session judges. So there are 3 types of session judges. So session judge by name, as he's presiding over to that session division by order and by selection of the state together with the High Court, is the highest ranking officer in that session court. And as name says, he presides on the very serious criminal offenses, including that may entail the death penalty or life imprisonment. So he normally engages himself with those. The key feature of that is he handles serious offenses. He is appointed by the High Court, needs considerable legal experience. He can hear appeals from the decision of lower court. He can pass, for example, a JMFC passes an order which you are not completely satisfied with. You can go back and you can file an appeal with the Sessions Court against that JMFC order. A session can also pass a death sentence. They are empowered to pass any order, even the death sentence, but only difference is if a session court passes a death sentence, it has to be confirmed by the High Court. So it is subjected to the confirmation. So they oversee the session court judge. The session judge oversees the jury trials, if applicable, or the normal trial nowadays, conduct hearings, evaluate evidence, and delivers judgment in each and every types of cases. And he is also looking into the heinous and the major crimes, for example, murder, rape, robbery, and other serious offenses. While the additional session judge is a subordinate judge, as the name says, who assist the session judge. Normally, they have similar powers. It's the copy of the session judge is additional session judge. But the sole purpose why somebody would have made us additional session judges, because a single session judge in a single session area cannot be competent enough in terms of efficiency that he or she can manage all the matters coming from that particular area and the rural area alone. So to assist him, multiple additional session judges are also brought into the session courts, and they were also appointed by the High Court. They can also uh, pass on judgment in any kind of offenses, serious offenses, and as the session judge can do. But sometimes the less complex ones are moved to the additional session judge, the matters, because the channelization of matter is in hands of the session judge, and it is advised because of his experience and his seniority. The most complex matters, or the matters relating to the highest level of punishment or crime, are mostly kept in the session judges court, and the additional session judges also get the serious offenses, but lesser than what session judge gets. Now there is somebody called assistant session judge. So assistant session judge is a lower ranking officer, primarily responsible for conducting trials of offenses that fall under a defined jurisdiction, often including lesser serious offenses, which is defined for that particular code by state government and the session judge with the instructions from the High Court for that particular state or that particular session area. So he handles a day-to-day trial, may deal with summary trial also, and ensure efficient workflow in a criminal justice system at the session court to dispose of the lesser serious offenses. So how this structure is working? Now I have a session area which is defined to ensure I have ample number of judges, ample number of infrastructure is number of courts, and ample number of court employees. I have looked into this particular combination depending upon the density of the people around, the people how can reach there in that demography easily, and it's easy for them to reach there. I mean, not very easy, but at least easy to reach there. And then we have a whole bunch of cases coming into the session courts, and then we divide it into three parts. The one sitting as a session judge there is the senior most person. This person is the boss who is managing whole of the session court, but then he is also assisted by copies of himself called additional session judges, because additional session judges are junior to the session judge in terms of the role, because they lack the primary administrative task. So the senior most person gets the most complex cases, and the lesser attributed cases are coming to the additional session judges. While the assistant session judges, as the session trial court is looking into the matters, criminal matters in the session courts, there might be matters which are very simple, not very complex, and might be resolved very quickly. And those are given to the assistant session judges, which are also in lesser experience, so which helps them to groom themselves, and they are normally not working in matters between 3 to 7 years of punishment, not more than that. So if we see the session court judges in all of this discussion until section 9, what we have been talking about, also some words like magistrate, judges, justice, those words we are using. So the CrPC has to be understood well. You have to understand, first of all, what are the different types of session judges. But then for practical application, you should also understand what is the difference between magistrate, judges, and justice. These three are not the same. So all the three are different, right? So magistrates are mostly judicial officers who handle a variety of legal matter, primarily in lower courts. So in lower courts, we have magistrates. Then session court onwards, we have judges. And high court onwards, we have justice. Okay, this is how the names are called. So magistrate typically deals with a minor criminal offense, civil dispute, administrative function. Jurisdiction can vary based on the specified laws of a state or a country. Now, there are different types of magistrates, which will come further in the section, but as the opportunity has come, I'll tell you now. Now, there are executive magistrates and judicial magistrates. So primarily when we talk about the legal criminal justice system, primarily we talk about whom? Judicial magistrates. They handle criminal cases, especially those involving minor offenses, into the lower level courts. While the executive magistrates are maintaining public order, executive administrative roles. For example, district magistrate, SDM, ADM, these are executive magistrate. Even some police officer senior level could be considered executive magistrate. In fact, further you will come to know, even a police officer could be a APP, public prosecutor. So the jurisdiction for a magistrate is working in a lower court, and they can issue summon, they can conduct trial also, and they can impose sentences for offenses within their jurisdiction, but not major crimes are taken care. For major crime, what we have session courts where we do the justice there. Now, judges are judicial officers who preside over court proceedings and make decisions in legal cases only. So magistrates have an administrative role as well, while judges might also have for internally managing the other judges, but for looking outside into the world, they don't have. The term is often used more broadly to refer to those serving in a various level of the judiciary, the judges, and there are district judges, session judges, and high court judges. So judges may serve in different courts, including the lower courts, the district courts, the appellate courts, and the high courts also. Now coming to justices, just one second. Justice primarily refer to judges serving in the highest order, senior judges of high court or Supreme Court. All the judges are called justices. So justices typically deal with significant constitutional issues, appeal cases, and landmark judgments that can affect law and precedents. So these justices are the people who bring all those things into the legal system, and these are called justices. And they have authority to make binding judicial interpretations. So what legislature does is legislature makes laws. When we say precedents and we say court-made laws, it's a wrong way of speaking. There is nothing called court-made law. Precedents has to be considered precedents only. These are interpretation of the various interpretation of the legislature made law in different application or different scenarios. So those precedents are created by these justices mostly, and they set precedent for lower courts also, and they take care of the appeals as well. So position level, if we see, the magistrates are in the lower court, the judges in the higher courts or the district courts, and the justices are typically senior judges in high court and Supreme Court. Now, coming to back to section number 9, subclause 6, it is something very, very important to know that the session court, when it is constituted, there is a place which is defined. So and so location, the court will be there. So and so court numbers will be there. So if any particular case, the court of session is of opinion that it will tend to general convenience to hold the court in some other place, not in the actual place of its where it sits, they have a power until section 9(6) that they can hold a court in any place which they believe for the reason of delivering a justice in the jurisdiction will be far more efficient and helpful to both the parties. So literally a judge can hold, as per section 9 subclause 6, a court anywhere he or she wishes to. Now we have session judge, additional session judge, and assistant session judges. Now, assistant session judges work in guidance of the additional session judges, but they report to whom? They report to the session judge, which the section 10 talks about the subordination of the assistant session judges. The session judge may from time to time make rules, he is the judge of the highest order in the session court, and the session judge may also make provisions for the disposal of any urgent application. Normally, a roster is made together with help of the registrar of the court, and they look into, together with the various law officers, they look into the bulk of the cases, and they divide depending upon jurisdictions, types of cases, who will look into what in which court. And that is how the registrar then posts the cases to those cases, those courts. Now, courts of judicial magistrates. So the moment we talk about judicial magistrate, one thing which is clear from the previous conversation in last 1 hour is there are two types of places. One is a normal, another is a metropolitan area. So whenever we talk about judicial magistrate, it's only from the perspective of the normal places of living, not the places which are defined as metropolitan areas. So if every district, there shall be as many courts of judicial magistrate of first class and of second class, and at such places as the state government may, after consultation with the High Court by notification, specify. Now, High Court will help. How many JMFC courts can be there? The presiding officers of such courts shall be appointed by the High Court, and the High Court may, whenever appears to be expedient or necessary, confer the power of a judicial magistrate of first class to any civil court judge also. That is also possible. Now, when we talk about judicial magistrate, and in the coming section, section 12, chief judicial magistrate, additional chief judicial magistrate. So we need to understand what is the difference between judicial magistrate, chief judicial magistrate, and the additional chief judicial magistrate to better understand this section. So let's talk about what is a judicial magistrate versus a chief judicial magistrate, and then we'll talk about what is a CJM versus additional CJM. Because until you don't understand the difference, it's very difficult to interpret these sections. So both of them are basically judicial magistrate only, JM and the CJM. JM consists of JMFC and JMC, judicial magistrate of first class and second class. They can take any kind of case, any kind of criminal case, and JMFC can go up to punishment matters up to which are punishable by imprisonment of up to 3 years, while JMC up to 1 year, as I said earlier. But CJM is the senior judicial officer. He is the one in whom every judicial magistrate reports into, and his jurisdiction authority to handle more serious crimes, more serious matters. So again, apart from that, he has got an administrative role as well, and he can also work on to the criminal matters which are of nature of bail matter as well. So they have power of judicial magistrate plus supervisory of authority, plus they can try more serious offenses. So JM, all of the JM, so judicial magistrate is inclusive of what? JMFC and JMC, and CJM is the senior judicial magistrate in that particular jurisdiction. Okay. So petty theft cases, small cases, the judicial magistrate will take care, and very serious, other serious offenses will be taken care by the chief judicial magistrate. Section 10 was talking about assistant session judge, which I told you. 11, court of judicial magistrate. So every district will have, which is not a metropolitan, will have a court, multiple courts of JM, which will be defined by the High Court. And if required, if there is a number of judicial magistrates which are supposed to be high in certain days, certain month, or certain point of time, or for some reason the JMs are not available, a civil court judge can also be given a power of a judicial magistrate by High Court. Coming to section 12, chief judicial magistrate and additional chief judicial magistrate. Now, chief judicial magistrate and additional chief judicial magistrate are one and the same. It is the scenario same the way we have for session judges. Session judges and additional session judges are meant to be having similar powers. But why additional session judges are there? They are copies of the session judge to work on the higher volume of work which is flowing into the court, and where only one could be leader, and that is the reason the CJM, the session judge is considered senior, while the additional ones, of course, have lesser experience and lesser criteria of being appointed. So CJM is a senior judicial officer who presides over the session of criminal courts at the district level and has administrative oversight of the judicial magistrate within the district. So he takes care of all the judicial magistrates. CJM is boss of all the judicial magistrates. So he falls within the jurisdiction of magistrate courts. He falls in the magistrate court category only. but might not be limited. He might takes the little complicated and higher level matters itself. Also, an administrative role is definitely, if you are chief CJM, you will have an administrative role. But additional CJM is exactly same as I said as the CJM, and he is somebody who works with the same powers, but he's somebody who is there to mimic, copy, or substitute the CGM in case he or she is not available. And this is required to expedite the. So it might happen that the CGM can delegate some task to the additional CGM regarding the roster preparation, maybe some other things. He can provide some guideline, and he has got similar power. So it doesn't block the CGM. Additional CGM can work with the guidelines from the CGM. So most of the time, he also takes the cases of the similar gravity what the CGM takes. Now, there is somebody defined by section 13, which is a bit confusing, as a special judicial magistrate. Now, what it means? We have known judicial magistrate, we have known CJM, we have known all the other definitions, but what is a special judicial magistrate? So, section 13 talks about special judicial magistrate. And the section says the High Court may, if requested by the central or state government, so to do, confer upon any person who holds or has any post under the government, all or any of the powers, conferred or conferred by or under this code on a judicial magistrate. So, special judicial magistrate is also a judicial power, has a power of a judicial magistrate only, of the first class or of the second class, whatever is told, or in case of metropolitan, uh, accordingly. Provide that no such power shall be conferred on a person unless he possesses such qualifications or experience in relation to legal affairs as the High Court may, by general or special order, direct. So what we understood from section 13(1) is the High Court does this appointment on request of central or state government. So these are specially requested people, special judicial magistrate for some special reasons. They have powers of a judicial magistrate of first class or second class. Mostly first class is given. But the person should have some basic qualification of understanding of law, some specialization in that area, should understand of the legal affairs, means how the courts operate, how the filings are done, how the trials are happening, and all those things are required. So, which is as per High Court, it is guided. Now, such magistrates, subclause 2 says, shall be called special judicial magistrates and shall be appointed for such term not exceeding 1 year at a time. So, they can only be there for 1 year time or lesser than that, as the High Court may, by general or special order, direct. The High Court may empower a special judicial magistrate to exercise the powers of a metropolitan magistrate in case it is in relation to metropolitan area. So if I make a judicial magistrate in one area, which is a non-metropolitan area, I can empower the same person to be a special judicial magistrate for a metropolitan area also, or vice versa. Now, these people who is for, if by the definition of section 13, these are people of specialized knowledge. Please understand, specialized knowledge or expertise in the legal process. Now, by the definition of this, the special judicial magistrate, a special is appointed for a category of offenses which may not fall within the conventional jurisdiction of a regular judicial magistrate. So there are some specialized cases. I'll tell you what. So their appointment is made under a specific legislation or with specific function designed by the local state authorities together with the High Court. And they are appointed by the state government or the Chief Justice of the High Court. But the appointment by the state government is done in consultation by the Chief Justice of the High Court. So we are talking about special judicial magistrates being brought into the picture. Now, their appointments are usually temporary, less than 1 year, and addressing specific issues such as certain types of economic offense or environment related, or maybe election, maybe some disease, for example, COVID. So the powers what they are given, these people are given, can be expanded or limited based on the nature of the offense. So they said JMFC 1 or 2, that's the max power they can have, but it can be expanded as well if required. So They can conduct trials, cross-examination, witness, make judgments on specific matter, which means they can do both summary and warrant kind of trial. Sentencing, depending upon the enabling legislature under which they are appointed, they can pass sentences and orders also as necessary. So they are not just dummy magistrates, they are somebody who could actually pass a sentence also. Examples, very good example is economic offenses. Special judicial magistrate may be appointed to handle cases related to economic offenses such as fraud, money laundering, other financial crime arising from laws like prevention of money laundering. So for money laundering, economic offenses. Now, environmental crimes, there is something which is, comes under the laws of Environmental Protection Act. Those things can come into environmental crimes. Public health, for example, COVID. Now, there are some very relevant cases around this where the appointment of special judicial magistrates have happened is A.R. Antuli versus R.S. Naik of 1998. Supreme Court addressed issues related to the appointment of special judicial magistrate and powers conferred on them to try specific offences. So a guideline was given, and the court emphasized the importance of independence of and impartiality in the functioning of the special. So they had to be given power of a judicial magistrate. They have their roles to be defined, their tenure to be defined, but they have to be given a complete freedom. Okay. So that is something which is very, very important. Union of India versus NN Missile. In this case, the court upheld the validity of special jurisdiction conferred on special judicial magistrates to ensure swift and effective administration of justice for particular kind of offences. So this is for very special kind of offences. MGP Yadav versus State of Maharashtra 2015. The Supreme Court reiterated the need for special judicial magistrates to address specific types of crime effectively, given the serious implication of such crime on society and the economy. So the judicial magistrates, special ones, which is defined under Section 13 of CrPC, are playing a very crucial role. But who could be? I've given you so many hints, so many if and buts, so many judgments. But who could be? So it could be a senior judicial magistrate with experience, proficiency in handling criminal law, maybe appointment as a special judicial magistrate. So already a senior judicial magistrate in judiciary service could be elevated to special judicial. Say, for example, I have a senior judicial magistrate who has some education in environmental science or robotics or such kind of things, or maybe he has been working in those areas earlier. That person has special knowledge in that area. That person could be elevated or can be appointed as a special judicial magistrate. Elevation is the wrong word. So he could be appointed as a special judicial magistrate. Then who could be appointed? Advocates. So advocate with extensive experience in environmental law may be designated as special judicial magistrate, such cases for environmental law or some other areas where they are specialized in their knowledge. Law professors and academics, for example, principals and the professors who have good experience, who have good, eminence. Eminence is very, very important, who are known in the community and the world or the country to hold that kind of special knowledge. Those could also be special judicial magistrates for some time being. Judicial officers from other jurisdiction. So it is quite possible that if I have somebody to be appointed as a special judicial magistrate in the vicinity of jurisdiction of Pune, and I know somebody who is available, such a judicial magistrate is available with such knowledge in some other area in Nagpur, I can bring that person as a special judicial magistrate for acting certain areas, for example, Pune. Then a district judge from any of the jurisdiction can also act as a special judicial magistrate. Retired officials, for example, district judges or former high court judges could also be appointed. Yes. So mostly they are the people who are appointed, or senior advocates are appointed. Practicing lawyers with administrative experience. If somebody who is running a legal firm, those people who have an administrative experience as well, because they are running a company as well, and members of regulatory authorities, some senior officials from SEBI and such bigger organizations are also allowed to be made special judicial magistrate. So Section 13 talks about special judicial magistrate. We talked about it. Section 14 talks about local jurisdiction of judicial magistrates. So subject to the control of the High Court, The chief judicial magistrate may from time to time define the local limits of the areas within which the magistrates appoint under section 11 and 13 may exercise all or other powers which they have respectively be invested under this code. So basically this talks about what is the jurisdiction of every magistrate, and it should be mostly as part of the district. It has to be extended through the district until and unless it is not called out that way. And if it goes beyond the district, in metropolitan area, the reference to this particular has to be taken, and High Court or the state government can pass certain resolution on permissions. Now we talked about the lot of judges, session judges, CJM, additional Chief Judicial Magistrate, additional session judge, assistant session judge. So all of these we talked about what is the hierarchy actually, who reports into whom. So we might have got confused by this point of time when we reach section 14. So 15 talks about the subordination of the judicial magistrate. The session judge comes at the top. So session judge, because we have divided the criminal area in the sessions areas, the judge which is which is the leader of that particular session is the session judge. So session judge is the senior most. CJM and the additional CJM, they report into the session judge. And additional session judge and assistant session judge have dual reporting. So the additional session judge and the assistant session judge in general are in control of the session judge. They are in control of the session judge on what they do, when they do, what kind of cases they take. But in terms of the hierarchy in the organization, they report to the person one step below to session judge, which is the CJM. So additional session judge and the assistant session judge, they do not report in department to the session judge. In spite of the name being additional session judge, they report into the CJM. So CJM is their boss. Section 16 talks about courts of metropolitan magistrate. In every metropolitan area, there shall be established as many courts of I'll call it MM in short, metropolitan magistrates. And at such places as the state government may, after consultation with High Court, by notification specify the presiding officers of each court by High Court, and 3, the jurisdiction and power of every MM shall extend throughout the metropolitan area. So it's similarly like the district court. We talked about the jurisdiction is up to the district. Very same way, there is the MM's jurisdiction, metropolitan area's jurisdiction is up to that metropolitan area. It might be extended as well if required. And the presiding officer is the chief metropolitan magistrate, which is also appointed by High Court, like any other metropolitan magistrate. And it depends purely upon the demographies, the population, and the possible number of infrastructure and logistic possibility for the people to reach there, that the number of such courts could be established. Talking about Section 17 is Chief Metropolitan Magistrate and Additional Chief Metropolitan Magistrate, which is appointed by the High Court. The way we have the judicial magistrate, the session judges appointed. Now, in relation to every metropolitan area, within its local jurisdiction, appoint a metropolitan magistrate to be the chief metropolitan magistrate. And the High Court may appoint any metropolitan magistrate to be an additional chief metropolitan magistrate. And such magistrate shall have all or any of the powers of the CMM under the code or under any other law for the time being in the force as the High Court may direct. So as I said, chief metropolitan magistrate and additional are same. Both are same. It's similar like, they have to be copies of each other to subdivide the work, while the chief metropolitan magistrate will have the administrative roles as well. The additional chief metropolitan magistrate, MM, is somebody who is an additional role to supplement him in his absence or to take power distribution with him. Special metropolitan magistrate. So the High Court may, if requested by the central or state government to do, confer upon any person who holds a conferable, or by under this code on a metropolitan magistrate in respect to particular case or to particular classes of cases. Now, this is exactly same how we talked about the special judicial magistrates. There is no difference. It is exactly the same. So these are the special knowledge people which we talked about in the judicial magistrate side, special judicial magistrate side. It is the same thing applicable. It's only because it is in a metropolitan area, it is called a special metropolitan magistrate instead of a special judicial magistrate. Section 19 talks about subordination of metropolitan magistrate. If you remember, we talked about the same in the section 15 for the judicial magistrate. We talked about session judge, below that CJM, additional CJM, and additional session judges and assistant session judges. After that, where additional session judges and assistant session judges have dual reporting in general control of session judge, while they also they are actually subordinate to the CJM. In the very similar fashion, in the metropolitan area, the session judge stands at the highest order. The CMM, the Chief Metropolitan Magistrate, and the additional CMM falls below to him in hierarchy. Then additional session judges and assistant session judges have a same dual reporting there also, in general control of the session judge while subordinate to the CMM. There they were subordinate to the CJM, here they are subordinate to the CMM. Now section 20 talks about executive magistrates. Now this is interesting. Now every district and every metropolitan area, the state government may appoint a person he deems fit to be an executive magistrate, which is mostly your district magistrate. Now, district magistrate and additional district magistrate are two roles primarily, which are called as executive magistrate. The ADM does not report to the DM. So, the state government appoints other executive magistrates also at the subdivision level. So, for example, SDM, which is executive magistrate at a subdivision level. There might be some other magistrates also, executive in nature, which will all report directly to the SDM at the subdivision level. But overall, they will all be seen and controlled by the district magistrate. So overseen by district magistrate as section 4A. The state government may place an executive magistrate in charge of subdivision and may relieve him of the charge as occasion requires, and the magistrate so placed in charge of a subdivision shall be called the subdivisional magistrate. So SDM is, which is a executive magistrate at the subdivision level. Section 21 talks about special executive magistrates. Now, we talked about special judicial magistrates. We talked about special uh, uh, metropolitan magistrate. Now, what is this difference between executive magistrate we talked about just and the special magistrate? So, special executive magistrate and the executive magistrate, what is the difference? So, we came to know via section number 20, the executive magistrates are officials who exercise power primarily related to maintaining public order and executing administrative function as prescribed by the law. So they are basically administrators. The powers they possess to enforce law, they are the executors. Maintain public order, handle minor criminal offenses, include they can also issue prohibitory orders under section 144 of CrPC, and small inquiries into specific matters they are empowered with. The executive magistrates are typically appointed from the administrative services, state or central. And the common position includes our DMs, ADMs, SDMs. And the judicial role, what they play is primary roles are administrative. They can also do some summary trials for minor cases. Something which has happened in the jurisdiction, somebody in the vicinity comes and wants to talk about, sir, this person breaks my bulb whenever I put a new bulb in my shop. There's a small shop I own, and somebody always is parking in front of my house, and then they are calling themselves a contractor who has won this place to be contractors to put vehicles on parking, etc. So small disputes can be taken care by the district magistrate also. They can do a summary trial right away on the spot and give a judgment, and they can pass an order immediately to that person. That is the power of a district magistrate. Same is the power of SDM, but at the subdivision level. But he or she has to consult the district magistrate and take instructions from her or him to operate. While special executive magistrates are appointed for a specific task or function within the realm of administrative law. So one thing is very, very important to be understood. Under section 20, the executive magistrates are defined, and they are people who are appointed by the center or the state government through the administrative tribunals, but administrative bodies. But the special executive magistrate which is coming to be a very specific role-oriented magistrate working on a specific area, is also still being part of the administrative services of the state. So they are appointed for designated function on time-bound task. For example, when we have an election, the district magistrate or the state government, in consultation with the home department, may put some executive magistrates to manage certain areas for the election related uh, nitty-gritties. So again, during emergency situations, for example, COVID, for example, some war happens, or maybe some communal situation has happened. In all those areas, some special executive magistrates are also appointed, which is something which is mentioned in section 21. So local jurisdiction of the executive magistrate is subject to the control of the state government. These are administrative people. State government decides what jurisdiction they will work. A district magistrate of a district can only work in that district because the name says so. But what role he can play, what all he can do, is all possible to be extended beyond what is the defined as per the administrative rules. And the district magistrate may, from time to time, define the local limits of areas within which the other executive magistrates may exercise all or any of the powers which they may have invested under this code. Except as otherwise provided by such definitions, the jurisdiction and powers of every such magistrate shall extend throughout the district like the judicial magistrate. So the baselining is same. The overall understood jurisdiction is district only, but the subdivision of the task is taken care, supervised by the district magistrate, which could also be a collector. So section 23. What is the subordination? We talked about DM, ADM, SDM. So who is reporting to whom? Which is talked about in section 23, which talks about the executive magistrate other than the ADM shall be subordinate to the DM. And every executive magistrate other than the SDM exercising power in a subdivision shall also be subordinate to the sub SDM, subject how to be general control of the DM, which I said earlier. And the DM may from time to time make rules or give special orders consistent with this code as to the distribution of business among the executives. So the DM is the senior-most executive magistrate defined under section 20. Then he has ADM, which is somebody who is able to take his position in his absence or for some reason. He doesn't reports into the DM. Then the other executive magistrates are there. The major one is the SDM in every subdivision. Then below that, multiple magistrates are there, and some special magistrates could also be there. They all invest their themselves into the district magistrate as a leader to them. So the reporting is invested that way. So on top is the DM. Then second level comes the executive other magistrates other than the additional magistrate. So additional magistrate is at par with the DM. Executive magistrate other than ADM comes next, and then all executive magistrate other than SDM in the subdivision report to SDM. So we have DM, then we have SDMs, and then we have all executive magistrates. In fact, all the special executive magistrates also, depending upon hierarchy. It might be a case some special executive magistrate might be investing their reporting into the DM directly also or SDM directly also, depending upon what is required. Section 24 talks about public prosecutors for every high court, the central government or the state government. So public prosecutor, as we know them as the government advocate, after consultation with the High Court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in such courts. So any prosecution appeal or other proceedings on behalf of the central government or state government, as this case may be. So any case in the criminal matter is a matter against the state, and these people represent the state. That is why it says any matter on behalf of the central government or state government, these people represent. The central government, the subsection 2 says the central government may appoint one or more public PPs or for the purpose of conducting any case or class of case in the district or the local court, while appointment can also happen via district through the state government. A public prosecutor can also be appointed, and they can also appoint one or more APPs. Now, provided that the public prosecutor, additional public prosecutor appointed for one district may appointed also to be a public prosecutor, additional prosecutor as maybe for another district. So it is not binding that you have to be a PP and APP at a same district or a same sub-district areas. You could be appointed for multiple areas as well. The district magistrate shall, in consultation. Now, this is very, very important and interesting. Section 24, subclause 4, the district magistrate shall, in consultation with the session judge, prepare a panel name of person who are, in his opinion, fit the appointed as public prosecutor or additional public prosecutor. So there are certain people who are eligible to be public prosecutor. Those are observed by the bar. In consultation to the bar, the session court judge is aware of that. And then with this, in consultation with the session judge, the district magistrate can also appoint a PP or an APP. No person shall be appointed by the state government as public prosecutor or additional PP for the district unless his name appears in this list. So until and unless this list, your name is not found, you cannot be an APP or PP. While subclause 6 says, notwithstanding anything contained in subsection 5, which is not being part of the list, where in a state there exists a regular cadre of prosecuting officers. So there are people who come through cadre, through government job also as through direct examination also to become a PP, public prosecuting officers. The state government shall appoint a public prosecutor or an additional public prosecutor only from among the persons containing such cadre. Provided that where in the opinion of the state government, no suitable person is available in such cadre for such appointment, the government may appoint a person as PP prosecutor from the list which we talked about together with this. So primarily it comes from the cadre. If cadre is not sufficient, the people are not efficient, and if that is believed by the High Court, the Session Court, the court can then go back and fall back onto the list which is prepared by themselves from the bar or by their knowledge of such people together with the district magistrate. So regular cadre of prosecuting officer means a cadre of prosecuting officers which include from them they're in the post of PP by whatever name called and which provides for promotion of APP. So there's a normal job-wise cadre or prosecuting officer means a person by whatever name called appointed to perform the function of a PP or APP can also be considered by any means if somebody is appointed. Section 24(7) says a person shall be eligible to be appointed as a public prosecutor or an additional PP under section 1 and 2 only if he has been a practice as an advocate for not less than 7 years. So if you are working as an advocate already in the court for up to 7 years, if you have practice, it is very much possible that under subclause 1, section 24, subclause 1, 2, or 3, the person could be appointed as a public prosecutor in various courts. The central government or the state government may appoint for the purpose of any case or class of cases a person who has been in practice as an advocate for not less than 10 as a special public prosecutor. So if somebody is more than 10 years and in some very special cases, various very famous cases which has happened in Pune court also, we have many senior advocates here who were appointed as a special public prosecutor also. But what is required is they need to have at least 10 years of practice to be considered as a special PP. Provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. So special PP, PP, APP, whatever happens, a victim can, or sorry, accused can, or a victim can also take help of assistance of other advocate also. So as PP and APP pertains to help the victim, so the victim can come back and request the court with the leave of the court, as we say, you can also appoint your personal advocate as well, who can assist the public prosecutor. They work in a way, they work as a special public prosecutor as well. Now, for the purpose of subsection 7, which is the person eligible with practice of 7 years, the subsection 8, where the person can be a special PP with practice years of number 10, the period during which a person has been in practice as a pleader or has rendered before or after commencement of this court service as a public prosecutor or as an APP or other prosecuting officer by whatever name called shall be deemed to be the period during which such person has been in practice as an advocate. So even if 7 years you have been not in practice, you have been in practice directly for some reason, you have been appointed after 7 years, say, into as a PP for few years, maybe a year or two. 2 years you have practiced as an APP. 7 years you have practiced as a pleader. 9 years total will be still considered, and only 1 year more will be required to be a special PP. So those numbers are also count. It should be considered, which section 24 says. 25 says assistant public prosecutors. The state government shall appoint in every district one or more assistant public prosecutors for conducting prosecution in court of magistrate. So in every magistrate court, if you go and see, you will see APPs. You will not see PPs because PP is one. So the central government may appoint one or more APP for the purpose of conducting any case or class, but there are some very special people who could also be considered as APP. For example, a police officer. While the law says no police officer shall be eligible to be appointed as an APP, but it is possible to appoint a police officer as an APP also if he has not taken part in the investigation into the offense with respect to which the accused is being prosecuted, and he is not below the rank of an inspector. So a person who is at the rank of inspector could also be by the state appointed, by the central government also appointed, with consultation with the session court and the high court as an APP. There is a department called Directorate of Prosecution, which is mentioned in section 25A. These are the people who manage the house for the public prosecutors and APPs. I leave it for you to read because this is something very, very simple. I'll quickly reach to on the last couple of sections as we are reaching the end time, 15 minutes. So chapter 3 talks about the powers of the court. The court of which offense are triable. So in which code you can try what? So subject to the provisions of this code, any offense under IPC or BNS could be tried in any of the courts, either High Court or Session Court or any such court or any other subordinate code. Any other law, if it is there, for example, from juvenile law, so Juvenile Act, special court is there. So for those courts also, there are specific courts defined, there it has to run. So jurisdiction in case of juveniles, if it is, they have done an offense which is not punishable with death or imprisonment for life committed by any person who is less than 16 years by the time of commitment of crime, then they can be tried in the court of chief judicial magistrate or any such court like juvenile court, which is defined in that country or in that state. Sorry. Section 28 talks about sentences which high court and session judges may pass. High court can pass any judgment. There is no upper bar. Additional session judges can pass any matter, any order, but if they pass a death sentence, it has to be confirmed by High Court. Assistant session judges can only pass orders which are not related pertaining to life, death, or which are not exceeding 10 years. That is what is mentioned in section 28 about the High Court, Session Court, Additional Session Court Judge, Assistant Session Judge. Section 29 talks about sentences with magistrates. What magistrates can pass. Now, CJM, as we know in hierarchy, comes below the session. Of course, if the session has a time limit of, assistant session has a time limit of 10 years, the CJM will have lesser. So CJM can pass anything except life, except death, not exceeding more than 7 years. Same is for the Chief Metropolitan Magistrate as well in the metropolitan areas. First class can pass not exceeding 3 years and not exceeding 10,000 rupees fine. While the second class magistrate can only pass up to 1 year and fines not exceeding 5,000 or both. Section 30, we have last 5 sections. I want to give you some time for question answer as well. Sentence of imprisonment in default of fine. Now, what happens if I don't pay the fine? So that there are clear, as there is a very clear, network of very rigid rule and regulation within the CrPC, which helps in this condition also. That what if somebody, passes an order and then this person does not pay? So the court of a magistrate may award such term of imprisonment in default of payment of fine as authorized by law, which is it is not in excess of the power of magistrate. So that magistrate do not have a power to pass any uh, sentence of imprisonment in default of fine, which is exceeding the maximum number of years he or she is authorized to fine to pass an order with. Shall not, where imprisonment has been awarded as part of the substantive sentence, exceed 1/4 of the term of imprisonment. Now, if I have given you a fine of rupees 500 as a magistrate, you have not paid, I can put you behind the bar not more than I am authorized to put anybody behind the bar for the number of years. But if punishment and fine both are given, in that case, if the fine part is not complied with only, I cannot give more than 1/4 of the term of imprisonment which the magistrate is competent to inflict. 32 says the imprisonment awarded under this section may be in addition to a substantive sentence of imprisonment for the maximum term awardable by the magistrate under section 29. So the imprisonment awarded this section for default of fine may be in addition to a substantive sentence also if required, but it cannot be an imprisonment for the maximum term awarded by the same magistrate which he is capable of. Section 31 talks about sentences in case of conviction of several offenses at one trial. Now, what happens is section 71 talks about of IPC. It talked about address the limitation on the punishment when an offense is made up of parts, each of which is also an offense. The offender should not be punished with more than one of such offenses unless specifically provided otherwise. For example, if A catches B and has committed an offense of beating him with a stick 20 times, will he be punished 20 times for the punishment of beating somebody with a stick? No. It will be considered as an offense made of the multiple parts, which is each of the part is similar offense, is an offense. So he can be punished only at once for this particular offense of beating with the stick. So offenses are composed of parts. If an act that constitutes an offense is made up of several parts and each part of itself constitutes an offense, the offender should not be punished for each individual part. Section 71 again says single punishment. So in this case, the offender is liable to only one punishment for the entire offense, which is a compound. If exception to this rule are also there, this rule does not apply if the law explicitly provides for multiple punishments for the part of the offense. Now, if the law says if something is defined that way, then it is mentioned that way, that multiple parts to be considered as multiple single offenses, then it has to be taken as multiple single offenses singularly. So, for example, our person who gave 20 sticks to X, Mr. X, he has given, Mr. A has given 30 blows. So he cannot be punished for 30 times for putting 30 blows. But Mr. Y came in between and tried to save Mr. X from this attack of Mr. A. He also beats Mr. Y also 5 times. Now this person can be punished for striking Mr. X and striking Mr. Y also, who has interfered. So he is liable for one punishment for causing hurt to X and another for beating the interfering person. So that is how it can be done. Section 32 to 35 are very basic, simple, straightforward sections. Mode of conferring power. It is a very technical section. So it says in conferring power under this code, the High Court or the state government, as the case may be, may by order empower persons specially by name, or in virtue of their offices, or classes of officials, generally by their official titles. Every such order shall take effect from the date on which. So this is talking about, you might have heard about GRs, appointment orders, this is talking about that. So it says any such order. So an appointment order is also a order of mode of conferring power. It has to be done either by the government, High Court or the state government. Say, for example, High Court together with state government is appointing so and so advocate from bar as a advocate, temporary advocate of the High Court. So what they are doing is they're by order on such and such date. It is reflecting. They empower that particular advocate by his name to become a High Court official, or in virtue of their offices. For example, they can come back and say empowering office of so and so officer to also have an additional role of so and so, or classes of officials. They can come back and say all the officers below the rank of sub-inspector or below the rank of a havaldar are also in state who have served for more than 10 years empowered to investigate a criminal matter. So they are empowering a class of people in this case. So this is basically a technical clause which talks about all of these. Section 30 talks about powers of officers appointed. So whenever a person holding an office in the service of government job who has been invested by the High Court or the state government with any powers, special powers under this code throughout any local area is appointed to an equal or higher office for the same nature within a like local area under the same state government, he shall, unless the High Court or the state government, as the case may be, otherwise directs or has otherwise directed, exercise the same powers in the local area in which he is appointed. So his powers cannot be challenged. His powers are tenable until the time which is given in the appointment letter, or if it is given for a longer period of time, and with whatever jurisdiction it has been given for whatever roles he has to be given. 34 talks about withdrawal of powers. If there is a power which is given, it has to be taken back also. So withdrawals of power, the High Court or the state government, as the case may be, may withdraw all any power conferred by this under the code, any person or by an officer subordinate to it, and any powers conferred by the CJM or by the district magistrate may be withdrawn by respective magistrate by whom such power were offered. And the last one talks about, the last section for today is powers of judges and magistrate exercisable by their successor in office also. In one line, I'll say this is based on common sense, where subject to the provision, the powers of the duties of a judge or magistrate may be exercised or performed by his successor in office as well, which is but natural. So this is end of section chapter 1, 2, 3, sections 1 to 35. I keep the house open now for you to ask questions. We have still 2 minutes, but I can extend for next 5 minutes. But next day sessions, please try to come on time. And Aditi, you try to have your camera tested and checked before you come to the call, please. You can unmute yourself.
Yes, sir.
Yes, I think your question, Aditya, was answered in the statement just after you asked the question.
Yes, it was answered, sir.
Any other question? Durga, Ashok ji, Aditya?
No, sir.
Sir, I think you're going to give us the notes, right?
Notes will come at the end, not
Yeah.
during the session.
So like the cases that you have mentioned, it will be
Yeah,
part
everything
of the
will.
note, right?
Yes, even the recordings will come to you after the session.
Okay.
After the final session, after the 20th session, you will get the recordings, not now.
All right. At few places, I found you to be little fast. So maybe if you could cover 1 or 2 sections lesser, that would still be okay.
No, this is a 20-day program, Ashok ji, and we have to complete depending upon the timeline. Yes, there might be my perception of certain sections to be in easier and not very important, but then wherever you find that it is not covered amply for yourself or you are not able to understand, I suggest, that's the reason I said you pick up your notebook and pen and note it there, because it's completely impossible for anybody to understand the difficulty. See, for me, the difficulty level is different, and for anybody else, it could be different. Yeah, so person to person, I do it as much as possible, understanding the student's perspective. But yes, I might be wrong. In those cases, I request you to kindly note down those points, and I'll immediately complete those post this session. if there is no question, I'll just switch off the recording, then we can talk for a minute.